Minister Tamisha. Ralamagela, in which Advocate Utama, you're going to proceed with the minister now, are you?
Indeed, Justice.
Yes. In which language do you want to testify, Minister?
In English.
In English. Would you put your full names on record?
Aaron Motsoaledi.
Do you swear that the evidence you're about to give will be the truth and nothing but the truth? And if so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Counsel.
Good afternoon, Minister.
Good afternoon, Counsel.
Thank you for making time to be before these proceedings. I should put it on record that in terms of the terms of reference which regulate these proceedings, you have been called to come and give an apology to the affected families who went through the tragic events of their loved ones having to die pursuant to the Marathon Project. We will not be limiting you on that aspect. We just want you to assist the families of how you have come to know of the Marathon Project and what is your relationship as the National Minister of Health in relation to the Provincial Department of Health. For the record, can you just indicate from which period were you appointed to the position of Minister of Health?
Thank you, Counsel. I was appointed as a Minister of Health from May 2009. I'm not exactly confident about the month, but it was after the 2009 elections.
As it is well known that these proceedings are as a result of the recommendations of the Health Ombudsman, who had investigated the circumstances relating to the death of mental health care users. It is quite clear that at the time of this investigation, you were and you are still the Minister of Health. Just to assist these proceedings, can you just take us through your relationship with the Provincial Department of Health as to how do you get to interact?
Yes, thank you, Counsel. My relationship with Provincial Department of Health is firstly guided by the Constitution, which states that health is a concurrent competence. This is important to understand because there are other departments which don't have any concurrence, like departments of Home Affairs, Science and Technology, Defense. They all have ministers who act on their own. But in health, there is supposed to be a concurrent competency in the Constitution, meaning that the powers are exercised both nationally and provincially. To that extent, the National Health Act 2003 states that the role and responsibility of the National Department of Health is mostly to come up with norms and standards, as well as regulations and policies. And the role of provincial departments is to implement those policies. Unfortunately, Counsel, something that I've been, through you, Justice, I've been canvassing in cabinet for quite a long time. This issue of concurrency is quite complex and very difficult at times. But it also, when you look at the Public Finance Management Act and the Public Service Act, both myself and the MECs are what is called executing authorities, meaning we have got powers to execute and take final decisions on any matter, meaning then that you have got an MEC in a province who's an executing authority, but equally a minister at national level, who in his own power is an executing authority. But now, because these powers are concurrent, quite a number of people believe the minister wields power over all the MECs, which is not necessarily the case. For instance, in 4 very important issues, which I even took to Parliament in August last year, to complain to members of Portfolio Committee that they must help us change that state of affairs. The issue of human resources, who gets hired at what level, it's not a concurrent function, it's a provincial function. There are people who have always asked me, why don't you fire this MEC? Why don't you appoint a better MEC? I don't have those powers at all. They vest in the hands of the Premier. So the issue of human resources, there are doctors who get fired and believe they've been fired unfairly, and they approach the minister for relief. If you look at that function, the minister gets in nowhere at all. The hiring or firing of doctors, nurses, etc., I don't have any powers over them. The only thing I can do is to persuade. That is the first one. The second one is financial management. There are people who believe ministers are the ones who decide on how much money must go to provincial departments of health at amounts. And I hope MEC Barbara Creasy has clarified it. Throughout her testimony, I'm sure he never mentioned the minister in giving finances, what program must get how much, etc. So financial management is purely in provinces. The third one is procurement and supply chain. As to what gets procured and get bought in provincial departments of health is a function of the executing authority and the accounting officer in that province, who is the MEC and the HOD. The last one is maintenance of equipment and infrastructure. I know people usually phone me and say, hey, this lift is not working in the hospital, minister, can you do something? I don't have any powers on those, unfortunately. Now, the unfortunate part, Council, through you, Justice, is that these 4 are the cornerstones of the healthcare system. If you fail on these 4, human resources, financial management, procurement, maintenance of equipment and infrastructure, if you fail on these 4, there's no health system, it collapses. And unfortunately, all those powers are not with the minister. And I thought it's important for all these issues to be understood, because many people do not necessarily understand them.
Thank you, Minister. At the outset, you have mentioned that your involvement is at the level of policy formulation. It is common cause that these proceedings relate to matters in respect of mental health care users. I would like you to assist these proceedings with regards to your involvement in the formulation of policy in that aspect. I'm going to ask someone to assist you to locate a file which is part of the record. Is file...
Is it this one?
No, file 4. File 4, there's someone who will be able to assist you.
It will be brought to you, Minister.
Oh, thank you. Thank you.
File 4, if you can turn to page 1358.
Yes. I can see it. But these letters are very small. Yes, I can see it, Council.
The norms.
Okay. Instead of this?
Yes, if you can make use of the document which has just been given to you.
Okay.
I think that will be of assistance. I would like you to to express your involvement with regard to policy formulation with reference to the document that is before you titled National Mental Health Policy Framework and Strategic Plan 2013 to 2020.
Yes, Council, this document is a document that guides how we implement the mental health services in the country. It's a policy framework, as it says, and also a strategic plan. It came into being after the World Health Organization got worried about the issue of mental health globally, that it is generally neglected, it is not funded like the other functions, and there's no involvement of families in the care of mental health users globally. And the Director General of the World Health Organization was instructed by the World Health Assembly to do something about it, which the Director General did. And eventually, the World Health Organization came with Mental Health Action Plan 2013 to 2020, which document is here in front of me. And in the foreword of the document, the Director General, or the then Director General, Dr. Margaret Chan, said mental health matters, but the world has a long way to go to achieve it. Many unfortunate trends must be reversed. And he says the trends are neglect of mental health services and care, and abuses of human rights, and discrimination against people with mental disorders and psychosocial disabilities. These are the words of Dr. Margaret Chan. And then he said, the objective of, this plan has got 4 objectives. The first one, to provide more effective leadership and governance on mental health. That's the first objective. The second one, provision of comprehensive integrated mental health and social care services in community-based settings. That's the second objective. The third one, implementation of strategies from promotion and prevention. And lastly, strengthening information systems, evidence, and research. These are the 4 main objectives of this mental health action plan. After it was drawn up, it was then felt that it needs to be localized to countries. This is a global policy with the 4 objectives. But obviously, countries are not the same. For instance, what they do in the UK will not be the same that I can afford to do in South Africa or another country in sub-Saharan Africa can do. So we had to localize it. And in localizing it, we realized that we need to come up with our own strategic plan. But we did not just sit as a minister or as a national department and say we are drawing a strategic plan. We first asked all our provinces to hold mental health summits where they must call all the relevant stakeholders, the communities, civil society, the academics, and experts. And all provinces did so. And that culminated into a national mental health summit, which was held in Ukuruleni. And the mental health summit was not just an ordinary summit, because we didn't just wanted to go through the motions. We wanted to come up with a clear country plan, strategic plan on mental health. So for that reason, we called experts. We called the director of mental health and psychosocial services from the World Health Organization to come and be with us and guide us. And we also called the country director of the World Health Organization in South Africa, and also the head of mental health in the whole African region of the World Health Organization, because the World Health Organization has got 6 regions globally. One of them is called Afro. So we called those, and we even called the judiciary. Judge Jody Kwalapen was invited specifically because he was the chairperson of the Human Rights Commission before he became a judge. These are the people who guided us. Now, at the end of that summit, we came up with something called a Ekurhuleni Declaration, which is inside this document. And that Ekurhuleni declaration then, after all those processes, led us to develop this National Mental Health Policy Framework and Strategic Plan 2013 to 2020. And it's supposed to be the document that guides all our provinces or anybody who want to provide mental health care services in the country. That's the role one has played.
Then in terms of this strategic plan, what are the areas of emphasis in relation to issues relating to mental health?
Well, remember that this document is also stemming from the National Health Act. Yes. Act number 17 of 2003, the Mental Health Act, I mean to say. The document also stems from it because you can't draw a strategic plan and a policy document outside the framework of the law, of the Act. Yes. So the Act was also guiding us. Now, I want to start there, Council, because it's important. The Mental Health Act, Act number 18 of I think it's 17. Forgive me about that. I think it's 17 years. Of 2003. It was replacing Mental Health Act, which I think is number 18 of 1973. It was replacing it. And the reason that it got replaced through you, Justice, is that Act number 18 of 1973 was giving immense powers to the minister in terms of mental health. Nothing could happen without me. Even the president, there are areas where they say the president, meaning the president of the country, must do ABC in regard to mental health. So it was giving a lot of powers, but it was devoid of human rights completely. Now, Act number 17 of 2003 was supposed to give that impetus to human rights. In other words, the core of the whole legislation on mental health is about human rights, seeing that you are dealing with vulnerable people. Now, the irony of that is that in that process, all the powers which the minister had, sometimes including the powers of the president, were taken down to the level of the MEC. And the MEC was given all those powers in terms of the 2003 Mental Health Act, so that they could, as the executing authority, do that. And the objectives were noble. It was thought that the minister is sitting high up there. The service, all the services are in the provinces. So it's better to take the authority to the provinces so that when people have to implement, they don't have to wait for authority from above, either from the president or the minister. They've got the authority right in their hands. So those powers were taken down from the national to the provincial level. And now, this document obviously was based on that. But there were very serious check and balances. Seeing that the power is now devolved to provinces, we had to put in lots of checks and balances. And one of the most important, powerful check and balance, Justice, is the mental review boards.
Sorry to interrupt you. Like, before you get to that point, can you just explain the organization of the mental health services in relation to that document at page 22? And in the record, it will be file 4, page 1368.
Oh, yes. Yes. You know, this document is quite big. But page 22 is a summary of what this document is all about. Yes, Council, it actually outlines the organization of services in terms of what Dr. Margaret Chan has said. And if you look at it, it's to make it easier, they put it in a form of a pyramid, so that even if you don't read this document, you just look at this pyramid. It summarizes for you. At the tip of the pyramid, right at the top, it says long stay facilities and specialist psychiatric services. And I'll tell you the significance of that, because there has been this word called deinstitutionalization, repeated all the time since this saga. Deinstitutionalization, deinstitutionalization. I'm actually trying to scratch my mind to find out where this word comes from, because I'm not sure. No, I'm not joking. I'm not sure, Justice. Mm-hmm. Because if you look at the Mental Health Action Plan 2013 to 2020 of the World Organization, it does not actually mention the word institutionalization. They talk about community-based mental health care services. That does not mean deinstitutionalization. And the top of the pyramid says long-stay facilities and specialist psychiatric services, simply because not all mental health care users can ever be deinstitutionalized or be sent to the community. There are people who have to be in an institution, unfortunately, unpalatable as it is. In other words, you can't take a collective decision that I'm now deinstitutionalizing or I'm doing community health care and everybody must leave an institution. There are just people who won't leave. Justice, I'm sure you are aware, even in correctional services, the same. There are people who are in jail, unfortunately. Oh, I'm using a very wrong analogy because these people are not in jail, so let me leave it. My apologies. But I just want to show that there are people who, unfortunately, against all our wishes, have to stay in an institution because of their condition. Now, below that tip of the pyramid follows two things which are in parallel. One is psychiatric services in general hospitals, that you can actually provide these psychiatric services in general hospital like any other hospital, rather than a special psychiatric hospital. Then next to it, it says community mental health services, which is what the document of the World Organization is all about, community mental health services. Then below that, it says primary health care services for mental health. I'm sure you are aware of the definition of primary health care. It's a basic health care service that has got three characteristics. One is prevention of diseases. Two is promotion of health. And three is when you use the healthcare system, you must stop that at the bottom, not at the top, not at tertiary service, etc. You must start with the clinics. That's why we're in the process of improving our clinics to become ideal. After that, as you move to the base of the pyramid, it's informal community care, where you can provide mental health care services informally in communities. And at the bottom of the pyramid, it says self-care. This is how mental health services will be provided in the country. And as you can see, the word deinstitutionalization doesn't appear on this pyramid, unfortunately. That's why I say sometimes I get very confused as to where did it ever emerge, where was it started being used officially in government documents, because I'm not sure. Let me leave it there, I'm not sure.
Would informal community care imply accommodation and institutionalization? In other words, is that a layer of service inclusive of continual care of chronic patients? Or is it just a layer that would give support? In other words, simpler put...
What it means, Justice, is that
yes,
all these layers of the pyramid can coexist when you provide mental health care services. It's a guidance that all of them can coexist, and they can all be applied depending on a particular mental health care user and depending on a particular setting. But all I'm saying is that the word deinstitutionalization, because my worry, Justice, is that people believe deinstitutionalization means moving people out of the top layer, the tip, the long-stay facilities and specialized psychiatric services.
Where would an NGO fit in the pyramid, if anywhere?
Well, according to this document, Justice, it says the government must fund NGOs in order for the NGOs to capacitate these layers. For instance, if you think there's a community mental health service provided in a particular community, you can fund an NGO that goes to train those people on how to do it. You can also, if self-care, it means a person who's better off, who understands that is mentally ill but needs self-care and support, you can get NGOs to help them. Now, I had arguments that, yes, NGOs can also, because there are many already in the country who are dealing with mental health care services. But unfortunately, in this booklet, we did not necessarily put that directly, because justice, when you remove a person from a big mental institution and put them in an NGO, that is still institutionalization. You are just deinstitutionalizing them from a bigger institution to a smaller one, which might even be more restrictive. If you look at the Ombudsman report, he is saying so, that he's worried that mental health care users were removed from a more freer environment, which is bigger, to a small house. I heard you, Chief Justice, congratulating the MEC for Health for you coming from the same village in Atteridgeville. Yeah. Unfortunately, that's where most of the mental health care users died, in a very small place. Yes. Oh, that was not meant to be. Chief Justice, I hope that did not mean to be any pun or what. I'm just saying so. Now, if you read about the Ombuds, about where they died.
I'm not sure if the pun was unintended, Minister.
Absolutely unintended, Justice.
I'm not certain.
I realized it when they are laughing. Absolutely. I was just wanted to give this example. Where they died is restricted. You just remove them from an institution where they were freer, they could move about. I mean, the reason that I'm quoting Atteridgeville, you know the yards there. The apartheid system, which was putting people in areas where the yards are very small. How then do you put mental health care users in that institution? It's just something that can't happen or cannot be allowed.
To get to the next step, Minister, the takeaway here is the decision was totally irrational and inconsistent, certainly, with the policy framework, and also, obviously, plainly inconsistent with the Mental Health Care Act. Isn't it so?
Absolutely.
Yeah.
And that appears in the Ombuds report.
Yes, in the Ombuds report. And the decision to shut down all of Life Esidimeni is equally irrational from what you're saying. You're urging us to take away that you cannot possibly have everybody being suitable to be moved to an NGO.
Well, you can close Life Esidimeni if there are compelling reasons. But then, with the understanding that the people, if you send them to communities, some of them need to go to an institution. And we've got institutions which are equal to Life Esidimeni, if not better, like Sterkfontein and, Vescopis, etc., which have been there for ages, where people have not experienced what they experienced when they moved out. So
of course,
the closure itself, if there are very good, compelling reason, is not necessarily wrong, but the question is, where are you taking the people to?
Yes, that must be correct. I don't want to digress unduly. I think, Council, you must go ahead. But we know that SADC went to all of the institutions, the excellent ones you're talking about, and they were full. And there were long waiting lists. So the decision to close Life Esidimeni was irrational just from that point of view alone, because there was no institution that, in fact, could receive chronic patients from Life Esidimeni.
There is a structure specifically established in terms of the Act, which should have done that, not SADC, actually. There is a legal structure. And it's not only a structure, it's a quasi-judicial structure. And in my layman's term, Justice, I understand a quasi-judicial structure, the only person more powerful than it in this whole house will be yourself as a judge. All the others, including myself, will fall under that quasi-judicial structure in terms of their decision. They are the ones who should have visited there If somebody is saying, I want to send these patients to Sterkfontein, they are the ones who should have gone there. And they are called the Mental Health Review Board. The review board, they are the ones who should have, they had powers, not SADC didn't have powers. They just work in mental health, they can just advise. But that mental health review board has got powers to go and say, no, it can't happen. We went to Sterkfontein and this and that reason, no, this cannot happen. And so nobody can go there.
Minister, we have come to know that when Life SD was closed down, the mental health care users were sent to various NGOs. You have just mentioned the Mental Health Review Board as a body which should have intervened during that transfer. I just want you to elaborate further on that matter with reference to a document which is supposed to be before you. We have marked it ELA 170. It has been circulated.
Oh. This blue one.
Yes.
Yes.
If you can proceed to elaborate as to how could they have assisted or intervened when these mental health care users were removed from Life SD. We will deal with when the date during which you have become aware, but like if you can just try and assist and elaborate on the roles of the Mental Health Review Board.
Through you, Justice, I want to put it on record that of all the checks and balances to safeguard the right of mental health care users in terms of Act number 17 of 2003, which specifically, among other things, was established, the Mental Review Board, the Act was specifically saying the Act is being enacted, one of the main reasons being to establish Mental Health Review Board. If there is any structure that was specifically put in place to protect the rights of mental health care users, is the Mental Health Review Board. And to that extent, in 2007, the Department of Health produced a document, Mental Health Review Board, Orientation Guideline and Procedure Manual. That was long before I came into the Department of Health, because the foreword to this document was written by Deputy Minister Nosizo Madlala Rutledge, who was the Deputy Minister at that time in 2007, just to emphasize the powers which was being given to Mental Health Review Board.
But you know, Minister, let me just come in there. Late in the day, the evidence shows us that that review board collapsed completely. It believed it was hired by the MEC. It believed that it was simply on a payroll and that they had to do their work. So I wonder how much time we want to spend on that. The evidence shows that they collapsed completely, misunderstood their role, and in fact, because of their inaction, all these safeguards were never helpful to anybody. If anything, they worsened the position of the mental health care users. So we'll have to decide just how much time we spend on the framework in the face of this devastation.
I'll spend a few minutes,
Yes,
but I think, yes, I think it's important, Justice, because I'll tell you why. In the UMPA's report, it said the Gauteng Mental Health Review Board was moribund, and the UMPA's recommended that the chairperson be charged. And the chairperson went through that DC and was not found guilty. And I think we discussed with the PM and the MEC that we need to review. Actually, more than the UMBAT, as I'm sitting here, I am surprised why this should just be a neglect of duty. I suspect it's a criminal conduct, which must be charged criminally. And I will tell you that, and I'm saying this with all due respect, Justice. What happens if a judge fails to perform their duty? I'm sure you'll know, but if a judge who's supposed to sit on a case that will save human beings dismally fails to discharge their duties to an extent that those human beings perish. And I want to read just, 4 lines.
Yes,
In other words, it's sort of 4 paragraphs. I'm leading it in lines. In the introduction of this document, which is guiding document, Deputy Minister Routledge says, in this orientation, guidance, and procedure manual, we examine the context of the establishment of the review boards, why they are critical to promoting human rights and justice, and how they can effectively function in the best interest of users. She goes on to say, as a quasi-judicial authority, boards have significant legal powers that must be administered with clear knowledge and understanding of the intention and spirit of Mental Health Care Act, as well as international and regional treaties and guidelines, and inform the existence of functioning. This is what you are saying. And now it goes on to say, this is the 3rd one I'm reading, so I'm not going to take a very long time. It goes on to say, they should adopt an attitude of active inquiry. This means looking beyond the documents and other evidence before them in order to assess whether particular recommendations or decisions are indeed in the best interest of users, or whether they reflect no more than the usual way of doing things, or are for the convenience of others, meaning others rather than mental health care users. Yeah. And it ends by saying, particular vigilance is needed in the case of users who have been receiving care, treatment, and rehabilitation over extended periods of time. To me, this speaks directly to life domain. That particular vigilance in that case, because these are users which have been there for a long time. The last one I want to read, it says, they should be seen as independent in reaching decisions. This means taking an impartial and unbiased approach and being open to hearing and weighing a variety of standpoints, including those of the user himself or herself, before making a decision. This places particular demands on review board members, more so if they are mental health care practitioners who happen to be in the employ of the state. They need to ensure that no questions can be raised regarding their independence in considering cases involving state institutions. This I believe. Now, I understand some said they did not know their functions. They did not know that this function exists. They allowed Dr. Manamela to appoint them as public servants. I won't easily accept that justice. They were appointed by the MEC Julie in terms of the law in November.
Minister, there is a document which has been placed before you. It's LR 171. Are you able to deal with that document? Do you recognize that document?
Yes, because I was saying, yes, it's exactly what I was talking about. I won't really accept it. They were appointed in November of 2015. Their first meeting in Gauteng was on the 6th of January 2016. And in their minutes, they say a copy of this guideline was distributed to all members and they were requested to go through it. And the resolution of that meeting says the orientation guidelines will be then discussed in the next meeting. That means take this copy, go and study it. In the next meeting, we then discuss
Well, we know, Minister. Thank you for that. We've spent quite a bit of time already with them here, interrogating the framework, and we're very alive to it because council spent a lot of time on it. Moribund means, you would know better than us, you're a doctor. Moribund means near dead.
Yes. And I'm saying I wonder whether that near death is not a criminal activity.
Well,
for people of that nature.
We've looked at the provisions, and in fact, I don't want to express myself now. Still being a judge, I think I will leave it to there. But we hear the point. They came here and said they believe they were employed and they received 30,000 rand a month and something like that, and they were happy to do that. But council, you'll have to decide which are the areas which the minister is going to canvass.
Thank you.
It's nearly 7 p.m. So, and we are on the last witness. So you have to pick your priorities on what would be appropriate as a closing evidence for this hearing, which has been here for many, many weeks.
We are mindful
But
of
you're the one to guide us.
We are mindful of the time and taking into account that there's going to be cross-examination. I do not want to approach the examination in chief on assumption that questions are not going to be asked. The witness will have to cover what he considers to be important aspects in order to educate all of us in relation to matters which are very important to these proceedings.
Yes, very well. It's a very senior witness, and that's why we allow the latitude. And the minister is aware of what has been said up to now and what is appropriate at this stage.
Yes.
So we should maybe allow him a bit of freewheeling, but to get to the issues that he really would like to express.
Thank you, Justice.
The facts have all been put before us. We have loads and loads of facts already. So I leave it to you and the minister, but choose what is narrow, appropriate for the last witness for the day.
Thank you,
And
Justice.
he's arguably the most senior official to testify before us.
I'll do so, Justice, to limit the questions.
Yes.
Minister, we have come to know that the mental health care users, or some of them, were transferred from Life SD menu without their records, and they were transferred to various NGOs. You have been dealing with issues relating to checks and balances. Can you please just assist us to explain what was the role of the doctors at Life SD Many when patients were transferred from their institutions?
I wouldn't know because I was not aware that they are actually doing that. But what I do know is the role of a doctor in discharging any patient, whether a mental health care user or any other patient, because I've worked through that and it has always been a sore point, Justice. Doctors discharge patients not on the basis of groups. That's not allowed. You can't sit as a doctor and say, this group of patients, I'm discharging them because of this and that reason. Each patient must be discharged as an individual. And the decision to discharge is the decision of the doctor and the doctor only. And is based on clinical grounds and no other ground whatsoever, just clinical. And that doctor can take that decision and nobody, even the minister, can stop that doctor. For instance, if I go to a hospital and say, this ICU is full and the government doesn't have money, please discharge this patient. No doctor is allowed to do that, or no doctor should actually do that. If I insist, because in the Public Service Act says, if somebody who's senior to you forces you to do something that is illegal, unethical, or bordering on corruption or fraud, what do you do? And I've made this a standard question when I interview people. In the public service, it says it must be done in writing. Nobody must instruct you verbally to do something like that. It's not allowed. You just refuse. It must be done in writing. Now, if I then write and say discharge these people because the ICU is full and all that, the doctor ought to say, no, I can't. And what will then happen? For instance, if it is your wife, Justice, who you come and say, please discharge my wife. I want a home. Yes, I want a home, and you give very good reasons. And the doctor examines that, the lady and clinically says, no, she's not ready for discharge, and you have to insist. The law provides for what is called an RHT. He must then give you a form called RHT, refuse hospital treatment. You sign it. Then the doctor is in the clear because he's not discharging you. You are refusing hospital treatment. He is not prepared to discharge you. And I believe in this case, in any case where patients need to be discharged, I believe in that. I know, Justice, you're saying this is late in the day, but I want to give you an example because it happened to me and I'm just talking
Well,
through
I'm
it.
worried. First it was my village, now it's my wife. So
Apologies once more. Apologies
So I
once
fear
more.
for the example, the next example that will come.
No. It won't come into view. But it's a very important example. In 1981, the then president of South Africa, in apartheid South Africa, P.W. Botha, wanted to do something called consolidation of homelands. That means redrawing borders. There is a hospital in Limpopo called Shiluvane, which is a Shangaan name, but the hospital was falling under Lebowa government. The consolidation of the borders made it fall under Gazangulu government. I was still a medical student, but we were made to understand patients were taken out of there to their own tribal group hospital in terms of P.W. Botha's rule. That I was not involved with, but how I came to know about it was in 1985. I was working in Mapulaneng Hospital. 5 members of the Lebowa Legislative Assembly arrived in the hospital and said they want all the Shangaans to be discussed. They are cheated because they are paying revenge to what they did to the babies. And I'm a baby, by the way. What they did to the babies in 1981 when I was a student. Our superintendent called us. The other doctors were Swiss doctors. They knew nothing about our politics. There were only 4 of us from South Africa who were Africans. And he told us that, no, these guys, they come from parliament, they say you must discharge these people. We said, no, never. The only reason we'll discharge any patient, and individually, is on clinical grounds and nothing else. There can't be any other rule, whether it's from parliament or not. And we told them we're not going to discharge them. And they said they will fire us and all that. We said, no, you go in, discharge them. When you finish, when the last patient leaves, we live with them. We'll never work in this hospital. We'll go and look for jobs elsewhere. I'm trying to show that doctors have got power to protect patients from any artificial discharge. And that is our second mechanism, just like the Mental Health Review Board. And all those mechanisms were breached. That's what makes me cry about this situation, that we put up an act which protects human rights, and the human rights are completely thrown out of the window. All the systems that you put in place, people just ignore them. So I'm not being a populist when I'm saying, I'm wondering whether this does not border on criminal activity. Because these are the people who have got more powers than me. Why am I saying so? The quasi-judicial mental review board has got more powers than me. The doctor in discharging a patient has got more powers than me as a minister. I can't distract that doctor and say, discharge this patient if they think it's not justified.
Minister, the doctors at Life SD Many were relying on the cancellation of the contract that it had with the department. What will be your response from the explanation that you have given?
The cancellation of a contract is a government or governance or political activity, whichever, where you take it. But I'm maintaining that regardless of that, my relationship with the patient is not governed by that. That's why there's a Hippocratic oath between me and the patient. I might be having a contract with my employer who instruct me, but my contract with the patient is stronger than my contract with the employer. because this patient life is in my hands.
You see, counsel, is the question that, or does the question imply that doctors at Life's Esidimeni discharged the patients? Because the evidence seems to be different, though, isn't it?
Well, Justice, like I'm trying to lead the witness on the aspect that he has indicated in relation to the checks and balances of the doctors at institutions at which they have been looked after. So I'm just trying to make a comparison in relation to the doctors at Life Esidimeni as to whether did they have any obligation to have either refused to allow the patients from leaving the premises.
Well, the evidence before us is there was no formal process of a discharge, isn't it?
Yes, like
you can't point to a process of a discharge on the evidence. Can one do that? The patients were basically apportioned out.
Stolen.
Yes, they were contained or whatever the name was. But I mean, we didn't have a formal process where every patient individually was examined and was certified that they were properly due for a discharge from the facility. The facility was shut down, and the patients were carted in a variety of modes of transport to different places where they were admitted again without any doctors. I thought that is the evidence.
Well, Justice, what we know is that the doctors at Life Esidimeni were aware when the patients were being transferred. So I'm trying to test with the witness as to whether could there have been any role on their part when the patients were being removed from the facility.
And is the implication that they ought to have resisted?
Well, like I'm trying to test that with the witness.
Okay.
Well, I've just outlined the role that doctors play. If it was me, I won't discharge anybody because I'm being instructed to do so unduly by any authority whatsoever. Unless, and I'm emphasizing, unless it's an order of court, as you know, in which case I can't stand in contempt of court. So I was not speaking about Life Esidimeni specifically. I was speaking about the duties of each and every doctor in this charge. But if the patient is taken away from the hospital in any other activity, like the example I've given, if the members of Leboa government at that time got in and took anybody and threw them out, it's not me because I didn't sign there and say clinically I'm discharging this patient. Yes.
To cut to the chase, because we're getting it secondhand, you got it secondhand like us. The evidence is quite clear. It was a brutal process. Patients were bundled up with their little belongings into a variety of vehicles, and they were portioned and parceled out to different NGOs. And the admissions had no proper process where doctors were involved, except possibly a few instances. And at NGOs, there were no doctors in any event.
In that case, they were not discharged. And what the police need to investigate is whether that is an abduction. Yes, honestly, they need to. Whether people have been abducted or kidnapped or whatever, the police need to find out, because it means legally they were never discharged. Those
yes,
people.
There are many breaches of the Mental Health Care Act, Doctor, no doubt, and you know them better than all of us. And I hope the police will go and look. There are many offenses. That statute creates a number of offenses. And I'm sure the police and the NDPP will go and look carefully at the evidence we already have. Counsel, where next do we go?
Minister, let's now deal with what has been termed the Marathon Project, the project which was responsible for the transfer of mental health care users. Can you just indicate At what stage or when did you become aware of the number of deaths which resulted from the implementation of the marathon project?
I became aware on the 13th of September when the then MEC was answering a question in the legislature and say 36 people have died in NGOs. That's when I became aware that people have died and the number was put at 36.
Was there at any stage that any member of the civil society could have alerted you of the impending implementation of the marathon project?
That there is something called Gauteng Mental Health Marathon Project. I read it for the first time in the UMBA's report. That there was marathon, a project called the Marathon Project. The part that I knew was that Section 27 did approach the DG at the end of 2015 about the issue of the contract between Livis Dimeni and Gauteng Department of Health. And the DG informed me about it and said, no, she's taking up the matter with an HOD because it looked like an administrative, programmatic issue rather than a important governance or political issue, which I may say, which decision must be taken at the political level. She said, no, she's conducting the HOD and they are dealing with it. Then from there, I think, because they were threatening to take me and the Premier of Gauteng to court, and the DG said, no, what has my minister done? And he then said, no, it is this type of project, but I'll deal with the HOD. And from what I heard, the DG then conducted the HOD, and both Section 27 and Gauteng Department met, and instead of going to court on the 22nd of November, they reached an out-of-court settlement and drew a document on what's going to happen, which looked very good from what I've heard and from when I saw it later, that it was a very good document. It was agreements, which in the presentation to the UMBAs, the DG says she regrets why she didn't insist that it be an order of court. And she did not insist because the then HOD of Gauteng, Dr. Silvano, said, DG, why are we going to be forced to have this as an order of court? Because we are agreeing. We are agreeing with Section 27. We are agreeing that we'll work together. We are agreeing that we'll do ABC. That's the part I knew.
You have just mentioned that the National Director of Health was in contact with Section 27 in relation to these court proceedings.
The Director General, you want to say?
In the Department of Health.
Yes, Director General, not Director.
Yes. Yes.
Okay.
I just want to find out from you, did you ever make any contact with any member of Section 27 in relation to those matters?
You mean at that time, before the court case, etc.?
Yes.
No, I can't remember that.
Okay.
I can't remember that, except the letter that they've written to tell the National Department about this issue, which matter I said was taken over by the DG. The conduct, which I remember very well, was when Mr. Mark Haywood phoned me after these announcements in the legislature, because my memory serves very well, he was distressed as much as I was distressed about what has happened.
Yes. So you spoke to Mark Haywood after the announcement?
I remember.
Yes.
I speak to him quite often, lots of times.
Yes.
But I seem to remember that, yes, there was a discussion after the death, but the verbal discussion before that, I don't remember it.
Very well. Let's then deal with the measures or steps that you have taken once you have learned that this tragedy had actually occurred.
Well, the first thing I wanted to understand, what actually happened? How do people go and die in NGOs in such large numbers? I wanted to understand that from the MEC, because also it occurred to me that we have got the National Health Council. That's my other point of contact with the MECs. It's a statutory structure, National Health Council, which I chair. It consists of all the MECs, all the HODs, SALGA representative, and the head of South African Military Health Service or the Surgeon General, where every huge project is decided there and must be discussed there. So I don't remember in the National Health Council us sitting and discussing a huge project where large number of people will be taken to NGOs to an extent where they die. So fortunately, the MEC, the then MEC had an appointment with me to talk about Nelson Mandela Children's Hospital, which was on the 14th. So I waited for her. When she came, I told her, I asked her first about this issue that I heard that in the legislature you announced the death of 36 people, which is something that is quite scary and horrible that something like that must happen. We need to know, and hence I told her, I am going to ask the UMBAT to conduct an investigation. That was on the 14th. I said I'll ask the UMBAT. I'm just informing you because the UMBAT might approach you to like cooperation. And the reason that I thought about the UMBAT justice was because the UMBAT was specifically the office, to establish that office of UMBAT was specifically my idea. I was getting tired of people who actually receive bad treatment from our healthcare facilities. They run to newspapers, there are headlines for a week, and they forget about them. What happened? Then I said, we need to have a public protector for health. That's the word I used. The public protector for health. The person who works like a public protector to protect specifically health, people who use our health facilities, not only mental health users. And the UMBAT was then established by amendment of National Health Act 2003. We put in an amendment. He was appointed in terms of Section 81 of that amendment. And coincidentally, the UMBAT was appointed officially by myself in terms of the act in June that year. His first ever job was Life is the Many. I never knew that he was going to have such a huge, impactful job when he was appointed. So I thought about him immediately when this happened, and I phoned him. Unfortunately, I was on my way to Canada to attend the Global Fund meeting. I said, UMBAT, this is what has happened. You must investigate. But because I'm on my way to Canada, be gathering facts. When I come back, I'll give you an official letter of appointment. Not as an UMBAT. He was already appointed. I've already given that letter for appointment specifically to do this job, to outline what you must do. And I did so, and I left to Canada. On the 26th, when I came back, I actually gave him that letter. And the UMBAT logged it in terms of the act. When somebody, by the way, who lodges a complaint with the UMBAT? Any member of society, any human being can do so. And once you lodge that complaint with the UMBAT, he must log it in. He or she must log it in and give you the log number. And the log number given to me was number 230 of 15/9/2016. That number was logged for me and Section 27, for both of us, because the UMBAT then said, Minister, while you lodged a complaint, Section 27 also did so. Yours came first, but because you did not put it in writing, Section 27 did so. Your writing only happened on the 26th. I'm logging both of you. And the log number 230 belongs to both you and Section 27, as the people who have lodged this complaint.
Well, the MEC says she did. MEC Mahlangu.
She did what?
She initiated and instituted a complaint with the Ombudsman to conduct the investigation.
Well, if she did it before me, then I was not aware. I'm sure the UMBAT can answer that. Because he told me that the log number 230 is for me and Section 27 because we lodged the complaint. He never said anything about the MEC. If he did, I'm sure he'll be the right one to answer that question, Justice.
Counsel.
Thank you, Minister. And then once I mean, like, after having lodged this complaint with the Ombud, what other measures did you take in relation to those mental health care users who were transferred to the NGOs?
I arrived in Canada. Then it occurred to me, because I spoke to him on the 14th, and we agreed that when I come back, I'll write him the letter, but he must start gathering facts. I arrived in Canada. It just occurred to me, by the way, I don't even know the conditions under which these people died. And the Umbud is still going to gather facts and wait for me, because I was going to go via New York to attend the United Nations General Assembly. I said, what if whatever is killing these people, what if it continues? By the time I come back, and what if it continues? I then realized this is trouble. The Umbud is not going to help to stop more death. I've got a ministerial advisory committee, which has just been appointed in terms of this act, and we appointed it, I think, I can't remember the date. It was quite recent, which is chaired by the head of psychiatry at Sefako Makati University, Professor Diamond. I then phoned him. I said, Prof, this has happened. I've officially asked the Umbud, but I'm scared that more people may die. Please, can you, over this weekend, visit all these NGOs, especially the ones where lots of people died, see what is happening there, and don't wait for anything. This is a state of emergency now. I didn't even know whether I've got those powers in state of emergency or what. I said, close them down immediately. Wherever you see that there's a possibility of somebody dying, close it down immediately. We'll come and talk about the legalities later. That's what I told them. But then they said, no, we need a written document because it's a serious matter. And right from Canada, my office told me it's possible. They then wrote a memo. We defined the purpose, what must happen, the budget, what the committee must do, who must be in the committee, and I signed it and I sent it. I then phoned the MEC and Dr. Sullivan. I told them that I've just appointed the ministerial committee to do work before the Umbud to save lives, and I want you to cooperate with them. The MEC then said, no, she would like to go with them wherever they're going. I said, fine. You can accompany them, because anyway, they were going to look for the list of the NGOs from you. I then hear from Professor Rataiman that one of the first NGOs they visited, I don't know in what order they visited, is Precious Angels in Attridgeville. Unfortunately, this is a fact, a justice. It's just a fact. And they found the situation scaring. And Professor Rataiman phoned me and said, this is absolutely horrendous. And I said, close it. He said, no, you, minister, and me do not have powers to close any institutions that was contracted by Gauteng. Gauteng must close it. And so he spoke to them. And I said, what if they refused for whatever reason? But fortunately, they never refused. He asked them, he asked the HOD. In fact, he said when they visited Precious Angels, they were with the HOD, Dr. Silubano. They told him, no, close this issue, these Precious Angels immediately. And I understand then they even reached to the MEC, because Dr. Silubano, according to Professor Rataiman, was doubtful. And the MEC said, I'll close it. And I told them that if she didn't close it, I was going to go to court immediately, because I don't have any legal powers to do that. I was going to ask the court to give me powers to close it. And so Precious Angels was closed immediately. From there, 4 other NGOs were closed by the Umbud, as he started, seeing that example, that even if the report is not yet out, where you see that more human beings might die, we have got to act.
What has been your interaction with the Premier of Gauteng in relation to the intervention measures that you had taken?
Of course, the Gauteng Premier being the boss of the MEC, I had lots of discussion with him, because I also wanted to understand does he understand about this. I'm not in the Gauteng legislature. He's the most senior person in government. I wanted to ask him, what is this whole thing of these people who have died? But I said, Premier, the most important thing, because I also have to inform him that I've asked the Umbud to investigate, he must know. But I said the most important thing now is to stop more deaths. And we need to do so. And I was happy to see in the UMBA's report later, 3 months later, that that act actually stopped more deaths from occurring. And I said, Premier, this is what we are going to do. There is the office. That's why if the MEC refused, when the ministerial committee said precious entries must be closed, I said I was going to go to court. But obviously, I was going to the Premier first because he has got power over the MEC, not me. And that's another issue which people don't know. They believe we have got powers to instruct MECs. When I told you they are executing authority, they might cooperate, they might not. Fortunately, in most cases, they cooperate, but not in this case of Gauteng, so-called Gauteng Marathon Project. There was no cooperation.
Thank you, Minister. As I've said earlier on, that you have been requested to proffer an apology to the affected family members. I would like to pause at this juncture to allow the families, through their legal representatives, to pose any questions to you, and then you'll thereafter render your apology to the family members. Those are my questions in examination, Justice.
Thank you, Counsel. Thank you, Minister. There are 4 sets of advocates, so there's going to be a bit of a grind here. Let's see how many questions they have for you. Advocate Hassan or Advocate Steyn?
Thank you, Justice. Advocate Steyn will conduct the cross-examination.
Advocate?
Advocate Steyn, Minister. My name is Nikki Steyn.
Nikki Steyn.
And I appear with and am led by Advocate Hassim, representing bereaved family members.
Okay.
Minister, I'd like to start off by thanking you on behalf of the family members for appearing at this arbitration and for availing yourself to give evidence and availing yourself at such a late hour. I hope not to keep you too long. I would like to just address 2 issues with you before we move on. The first being recommendation 14 of the Health Ombuds recommendation. I will read to you the relevant portion. If you'd like to follow, it's in file 1 at page 58.
Is this file 1?
Somebody will come and give you a copy of file 1.
At page?
At page 58.
Oh, the file is overfull, it's flowing over. I'm sure they'll come and rearrange it. I'm sorry, yes. Yes, I can see page 58.
Are you at page 58?
Yes.
Okay. Minister, you spoke in your evidence in chief about some of the challenges that you faced with the national and provincial, the relationship between the national and provincial health departments. Recommendation 14 of the Ombud reads in part, there is an urgent need to review the National Health Act of 2003 and the Mental Health Care Act of 2002 to harmonize and bring alignment to different spheres of government. I take it, in the light of your examination in chief, that you agree with this recommendation.
Absolutely.
Has this review of the Mental Health Care Act and the National Health Act commenced?
Oh, yes. In fact, I'm made to understand that we are likely to get a report by the end of March. It's been done by the Law Reform Commission. Because what the Ombuds here is saying is that some of the things in that act have led to this. And I say that's why I'm saying it's an irony. The act was supposed to make sure that human rights, are respected. But it so happened that there was weakness because the powers were taken from above to a lower level where the thought services were, and it led to something like this. So he said they must be reviewed, and they are being reviewed wildly. both the National Health Act and the Mental Health Act. And the DG, as Stas told me, I'm speaking under correction from her, that the Law Reform Commission told her that they are like to give us the first draft in March, because it started immediately after the Ombuds report.
Minister, will there be an opportunity for stakeholders and civil society to comment on the draft report?
Oh yes, we can't make a mistake. If we do any bill, we will. After what has happened in terms of the strategic plan, which says you must involve civil society, stakeholders, etc., we won't make such a mistake. Definitely not.
Thank you, Minister. My final question to you arises in the context of your constitutional obligations in your position as Minister of Health. And the question is this: is there anything that you believe you could have done to avoid this terrible tragedy?
Yes, as I said, if had I known that something like this is being planned, first of all, I said it would have been discussed in the National Health Council, where all the MECs are, the Surgeon General of the Military Health Services, SALGA, and all the HODs, and all the DDGs at the National Department. All of them put together, they will have known whether something like this could happen or not. And I believe it would have been stopped. But unfortunately, the matter did not even come there. I don't understand why such a big issue could not have come there. And the people who were involved in this know better, because justice, when we launched the biggest HIV counseling and testing campaign, I still remember that very well. We had a whole week retreat in Mpumalanga where we're outlining when you do such a big thing, what do you do? And I still remember MEC Mahlangu then, because she came twice to the department. She was the MEC from 2009 and in that 2010. I still remember, because she's not a health person, asking very deep questions. And I remember what she asked. What is the side effects? Because we're talking about possible side effects of medicines. What is pharmacovigilance? And we said all these things must be discussed thoroughly, because we are coming with a huge project. And I want to believe this should have happened also.
Yes, indeed. But the question is a little closer home, Minister. The question is there anything, as a matter of hindsight, that you could have done to help prevent the disaster?
Oh, yes. If I knew that was going to be such a disaster, justice, I would have done a lot. I've already told you, one could resort to courts of law. I could have spoken to the Premier and say something like this is supposed to happen. We have got powers over the MEC, which I would have gone to lots of authorities to make sure that something like this doesn't happen.
It's another way of asking, is there an omission that you are able to identify now that would make you say, damn, if I knew then, or damn, I would have acted differently?
Well, maybe after Section 27 wrote to the department and the DG was dealing with this matter, because I thought the DG is well capable of dealing with it, maybe. But this is with hindsight. One should have said, hey, can I sit with the DG and ask him if he would like help from me? And maybe something might have emerged. But because I thought she's competent enough, and also because the agreement between Section 27, I don't think there's any human being, even Section 27 itself, which will have guessed that Gauteng Department of Health would renege, because they completely reneged on what they did and signed. And obviously, with hindsight, I would have advised the DG, please, even if even if they say they are not refusing, they are agreeing, let this be an order of court. But unfortunately, that I didn't do.
You see, Minister, the evidence is there were marches, television programs, press statements, agitation in a wide variety of ways, and all of those escaped you, certainly, or your office, until September the 14th.